Good, after- Good afternoon, everyone. Thank you for joining us today. My name is Connor Cox, and I am a panels coordinator for our symposium. Our final panel is titled Congress and Court Reform, Jurisdiction Stripping, Court Packing, and Beyond. Reform proposals have gained momentum in recent years, and this panel will explore whether Congress can or should take such measures to reform the courts. Panelists will examine the legal feasibility and potential impact of reforms, weighing whether these measures would preserve or endanger judicial independence. Our moderator, Judge Raymond M. Kethledge, is a circuit judge on the U.S. Court of Appeals for the Sixth Circuit. Judge Kethledge has taught federal courts and the fundamentals of appellate advocacy at Michigan Law School, and a seminar on classical liberalism and the rule of law at Harvard Law School. He received his BA in history from the University of Michigan and his JD from Michigan Law School. He clerked for Justice Anthony Kennedy of the U.S. Supreme Court and Judge Ralph B. Guy Jr. of the Sixth Circuit. He also worked in the U.S. Senate and later, with two partners, founded a boutique litigation firm, now known as Bush, Seyfarth, and Page in Troy, Michigan. His practice there included a broad mix of trial court, appellate, and class action litigation. Judge Kethledge is also the co-author, with Mike Irwin, of Lead Yourself First, Inspiring Leadership Through Solitude. Professor Jamal Greene is the Dwight Professor of Law at Columbia Law School. He has served as a Deputy Assistant Attorney General in the Office of Legal Counsel at the Department of Justice and as a Senior Visiting Scholar at the Knight First Amendment Institute. Professor Greene is a graduate of Yale University and Yale Law School. After law school, he was a law clerk to Judge Guido Calabresi of the Second Circuit and then to Judge John Paul Stevens of the Supreme Court. He's the author of How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart, and numerous influential law review articles, including Rights as Trumps and The Anti-Canon. He is a member of the American Law Institute and serves on the Board of Academic Advisors of the American Constitution Society. Professor Tara Lee Grove is the Vinson and Elkins Chair in Law at the University of Texas School of Law. She has been published in prestigious law journals and has received awards for both her research and teaching. Professor Grove served on the Presidential Commission on the Supreme Court of the United States and a bipartisan commission charged with examining proposals for Supreme Court reform. Professor Grove is a graduate of Duke University, summa cum laude, and Harvard Law School, magna cum laude. After law school, she was a law clerk to Judge Emilio Garza of the Fifth Circuit. Professor Richard Primus is the Theodore J. St. Antoine Collegiate Professor of Law at the University of Michigan Law School. In 2008, he won the first ever Guggenheim Fellowship in Constitutional Studies for his work on the relationship between history and constitutional interpretation. Professor Primus is a senior editorial advisor of the Journal of American Constitutional History and has received the L. Hart Wright Award for outstanding teaching from Michigan law students 4 times. Professor Primus is a graduate of Harvard College and Yale Law School and received a DPhil in politics from Oxford University as a Rhodes Scholar. Before joining the Michigan Law faculty in 2001, he practiced law at Jenner and Block in Washington, D.C. He is also a founding member of the Academic Freedom Alliance and serves on the Board of Advisors of Protect Democracy. Professor Amanda L. Tyler is the inaugural Thomas David and Judith Swope Clark Chair in Constitutional Law at the University of California, Berkeley School of Law. She is the co-author with the Honorable Ruth Bader Ginsburg of Justice, Justice Thou Shalt Pursue, a life's work in fighting for a more perfect union, and the author of Habeas Corpus in Wartime, From the Tower of London to Guantanamo Bay. Professor Tyler is a graduate of Stanford University, where she played on the Division I women's soccer team, and of Harvard Law School, where she graduated magna cum laude. After law school, she was a law clerk to Judge Guido Calabresi of the Second Circuit, and then to Justice Ruth Bader Ginsburg of the Supreme Court. She serves as the co-editor of Hart and Weschler's The Federal Courts and the Federal System, and is an elected member of the American Law Institute, and is a past chair of the Federal Courts section of the American Association of Law Schools. Professor Keith E. Whittington is the David Boies Professor of Law at Yale Law School. He is the founding chair of the Academic Freedom Alliance's Academic Committee, a Hoover Institute Visiting Fellow, and served on the Presidential Commission on the Supreme Court of the United States. Professor Whittington is a graduate of Yale University and the University of Texas at Austin. Before joining Yale, he served as the William Nelson Cromwell Professor of Politics at Princeton University from 2006 to 2024. He is the author of numerous books, including You Can't Teach That, Repugnant Laws, Speak Freely, Constitutional Interpretation, and The Political Foundations of Judicial Supremacy. He is a member of the American Academy of Arts and Sciences and hosts the Academic Freedom Podcast. Please hold your questions for the Q&A session at the end. And with that, I am delighted to pass the floor to our moderator, Judge Kethledge.
How long are we going to leave for Q&A, by the way? 15 minutes? Okay, great. Well, I'm honored to be up here with this group today, and I welcome all of you to Michigan Law School. I'm a proud graduate of this school myself, and I really can't help but just make a few comments about our venue, particularly with a group of students here. I'm kind of getting over at the moment here the change to this room, because I had more classes in this room than I can remember. And it was kind of curved tables, and there was a raised dais over here, and it's sort of like, you know, coming back to your old neighborhood and your house is sort of doesn't look like your house, but it's okay. But it just makes me reflect a little bit on my time here at Michigan Law School. And the one class I had in this room that just really, I'll just remember for my whole life was commercial transactions with James J. White. And so Jim White was just this iconic law professor here at Michigan Law School back in, he started in the early 60s and I graduated in 93. But Jim was kind of like George Patton teaching commercial transactions. He was just a super vigorous questioner with a Socratic method, highly predatory in that regard. And but he was a great professor because he was both very challenging, but also inspiring. And so I think he just inspired us to kind of dig deeper than we had planned when we came into his class. And just the interaction and to get kind of a glimmer of recognition from Jim and respect just meant so much. You were willing to work so hard for that. And I'm fortunate that Jim really became a great mentor to me. We're still friends. We had lunch a few months ago down the street here. And so with a group of students here, I just do want to say that just remember, I know there's a lot of pressure with finals and, papers and all that kind of thing, but this can be a really rich time in your life. And just embrace it, appreciate it, and seek out good mentors who can guide you as you go forward. I had my investiture 15 years after I graduated. I had my investiture in this very room, and Justice Kennedy swore me in, right about there. And the opening speaker was Jim White. So those relationships that you make with other students and with your professors can be just really an important part of your life, and just make sure you have time for that. Okay, well, getting back on topic, we're supposed to talk about jurisdiction stripping and court packing, and I don't have any particular insights on those two things, except I do not like them. But I'll be open-minded up here. But we have a super distinguished panel, and so I think we're just going to dive right into it. And I think we're going to, Professor Greene, you're going to lead us off?
I am.
The topic of your choosing.
Okay. So I'm gonna try to do a little bit of a table setting here, but I'm gonna maybe do it in a particular way. I think gatherings of this sort are most productive if we can sort of start with a shared point of departure or shared set of premises that don't necessarily depend on one's particular ideology or particular views about judicial power. So I want to start the conversation by trying to take a step back from the particular conflicts that might be of interest to people and describe what I think of as a problem and that I want to persuade all of you that you should think of as a problem as well. As many of you are aware, John Adams, in writing the Massachusetts Constitution of 1780, famously described a republic as a government of laws and not of men. This, I think, should mean that it should not be the case in a republic that a tiny cadre of unelected elite lawyers decide many of the most important political questions within the society, serve in office however long they please, and routinely time their retirements to ensure that someone who shares their ideology ends up replacing them to then themselves serve under similar conditions. I think it should especially not be the case in a republic that an even tinier cadre of that already tiny cadre of life-tenured, unaccountable lawyers, in effect, decide a large number of the cases based on their own idiosyncratic views of the law, just because they happen to be the so-called swing justices on the court. This power can enable them to decide the shape of constitutional law for decades at a time. As law students, and some of you as lawyers or law professors, you are, of course, familiar with the phenomenon of important nationwide historic questions of constitutional law boiling down to, well, what does Justice Kennedy think? What does Justice O'Connor think? What does Justice Powell think? What does Justice Kavanaugh think? And this can go on for generations at a time. In fact, in the term that I clerked at the Supreme Court, there were 22 5-4 decisions on really important issues, ranging from school integration, capital punishment, abortion. Anthony Kennedy was in the majority in every one of those 22 5-4 decisions, meaning that in every one of those 5-4 cases, this one person changing his mind would chart the country on a dramatically different course on extremely controversial political and legal topics. In a democracy, in a republic if you prefer, no one person should hold that much unaccountable power for life, period. So the question, I think, should not be whether this kind of state of affairs is good in a constitutional republic. It's not good for this to be the state of affairs, but rather whether there's anything constructive and constitutionally permissible that one should do about it or can do about it. Now, I think that there is, and I'm going to kind of go through three options quickly and try to persuade you that you should all settle on the third. One way of solving the problem of a very small number of people exercising too much power over political questions for too long would be to limit their terms. To limit their terms of office so they're not doing this for their whole lives and then giving it to someone else who shares their ideology to do it for their whole lives. I think term limits are a good idea. I think some form of term limits are constitutionally permissible, but I do recognize, of course, that that's not the view of everyone. It's certainly, I assume, not the view of everyone in this room, and we'll have some doubts about constitutionality. So let's put that to one side for the moment, although we can return to it. I'm sure we will at some point in this panel. Second possibility of tackling the kind of problem of having a small cadre of lawyers deciding political questions forever, is to try to depoliticize their approach to solving those questions. So if they're not solving political questions, they're solving purely legal questions. And this is what I take to be the main, a main part of the pitch for originalism. Now, I don't think that the originalism movement has succeeded at depoliticizing the court. I don't think it can succeed at depoliticizing the court because I think that the text and history and structure of the Constitution just lack the resources to be able to resolve the kinds of political conflicts that divide us and to turn them into purely legal conflicts. I think that that's not very realistic. So what's the third possibility of the problem of too few people exercising too much power for too long is to make more of them so that it's not so few people. I think this third option, which is expanding the number of Supreme Court justices, has gotten much less attention across the political spectrum than it deserves. And part of the reason it's gotten much less attention across the political spectrum than I think it deserves is because it has been described as court packing and has been defended as a means of restoring ideological balance to the court. But expanding the number of justices on the court is not the same thing as court packing, and they have different justifications. Court packing is, by definition, partisan. That's the point of it. Court expansion that is not court packing can be accomplished in entirely nonpartisan ways. For example, by having the expansion begin at a later date on which we don't know who the president is going to be or what the president's political party is going to be. But what are the justifications for it? First, just some facts that you should be aware of. The United States is the third largest country in the world, but it has the smallest Supreme Court of any large country. Among the 30 biggest countries in the world, the United States has the smallest high court. It has the same number of justices as it had in 1869 when the country was 1/10 of the size that it is now. That is also, of course, before federal courts had general federal question jurisdiction. It's before the Bill of Rights were applied to the states in any way, before the rights revolution of the 1960s and 1970s. The larger Supreme Court that I'm going to ask you to try to envision might have, let's say, anywhere from 15 to 25 justices who sit not in bank, but sit in panels, just like every other appellate judge in the country, with potentially larger benches or potentially even an en banc court for the most significant cases. I will very quickly try to run through some of the benefits, and I'll list 7 for now. One, there would be less, and this, for me, this is the most important one, there'd be less power held by any individual justice. It's not a question of the power of the court in general. Lots of people can disagree about how much power the court should have, but any individual justice would have less power. And if that's the case, I become much less bothered by life tenure. I become much less exercised about term limits. 2, the court could hear a lot more cases. The federal courts in general hear many, 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 many more cases than they once did, but the Supreme Court has remained the same size. Third, you could commit a rotating panel of justices to hear, for example, so-called shadow docket cases, so that it doesn't pull the court away from its regular work. One of the complaints of the shadow docket being they don't have enough time to focus on these things and then end up making kind of arbitrary decisions. Fourth, a bigger court would allow a subset of the court to resolve ethics complaints. One of the main contentions about the problem of applying an ethics code to the court is that they always sit in bank and it's hard to pull anyone away, and you don't want their cases to be reviewed by lower court justices. Well, that's not necessary if there are more people who are Supreme Court justices. Fifth, you could have a rotating certiorari panel so that the people deciding whether to hear a case cannot necessarily make predictions about the outcome. This would mitigate what I think are quite reasonable concerns, that in choosing its own docket, as the court largely has for the last 100 years, the court gives itself too much power over American politics. If you think about the Marbury versus Madison justification for judicial review, it falls apart, actually, if the court chooses all of its own cases. So it actually doesn't have to decide constitutional cases, but it chooses to do so. Sixth, because each individual justice would be much less powerful, the confirmation process would look quite different. It could be normalized relative to today. And seventh, a larger bench would give some birth for the diversity of life experience on the court, on a court that helps to govern a nation of 330 million people. So in short, much of the so-called politicization of the Supreme Court becomes a problem mostly because individual members of the Supreme Court themselves hold an enormous amount of power. That is something that can be changed. It can be changed by statute, and it can be changed without changing the power of the court as a whole, and without the unseemly specter of court packing, which I myself have some significant reservations about.
Okay. All right. Thank you, Professor Greene. I'm just going to open it up to the other panelists here. I mean, I think it could be a little stuffy to just go in order. So, I mean, if we behave ourselves and you know, give everybody a chance, I think we ought to just let folks speak as they're moved. That's a good rule, by the way, in meetings. I have this rule that I don't speak unless I'm moved to speak, and it really keeps you out of trouble, because when you're just talking to hear yourself heard, that's when you say stuff that's not very smart. So anyway, let's hear from our panelists. Or I'll talk. I could certainly talk about some.
Amanda has been telling me when to speak and when to be quiet since she was at my apartment the night I was admitted to the bar. And she's done it again.
I'm going to interrupt him for old time's sake.
Yeah.
In your wonderful introductions, you left out two really important facts in Richard's biography. First, he clerked for Guido Calabresi, which, by the way, makes this a half like Guido reunion up here. And second, he clerked for Justice Ginsburg. And I know this because he was my co-clerk both years. Now I'm done.
Okay. I agree with a lot of what Professor Greene has said. Maybe not all of it. I guess I should start with this. I think poorly of the United States Supreme Court. I don't think poorly of the federal judiciary in general. I think rather well of the federal judiciary in general. I think it's a pretty well-functioning institution with a lot of really smart people trying to do the right thing. And my thinking poorly of the United States Supreme Court is not a recent thing. I have thought quite poorly of the United States Supreme Court, at least since I had the great privilege of working there as a clerk, because I think it's a dysfunctional institution in many ways, and a number of them are traceable to the small group dynamic and the permanence of their position, both of which, if you don't have just the right people, create a culture in which people don't listen to each other very well. Or at least is liable to that problem and a number of the other problems that Professor Greene talked about. I think that I'm very much in favor, and again, as Professor Greene said, without, leaving aside for a moment as orthogonal, the question of whether the institution has more power than it should, I'm definitely in favor of measures that would cause individual justices to have less power than they do in various ways, including some of the ones that he mentioned. I should say, I have a suspicion that part of the resistance to court reform is the history that associates it with FDR packing and so forth, and because of the very real and I think justified concern that if the court were altered in ways that were overtly political or partisan or so forth, it would quickly cease to be able to play the check and balance role that we need it to play, because the judicial review only works if the competitors in the game of politics have a tacit understanding that I will sit still for it when the court goes against me, and you will sit still for it when the court goes against you. And if you have a situation where the dominant political coalition in the other branches can simply capture the court for its own side and have all the cases decided the way it wants, that equilibrium unravels very quickly, because then either that side uses its power to lock itself in forever, that's bad in a democracy, or power alternates and the other side then does the same thing and nobody has a good reason to respect the court. So I think all of that is bad. But that doesn't mean that we need the present structure. It doesn't mean that we need to have super powerful justices as we have them. I suspect that part of the reason that people are averse to the idea of trimming the power of particular justices down to size is actually this, and it's just a psychological speculation that's beyond my competence. I think that when most people who wind up going into law first learn about the Supreme Court, they think it's super cool. And they think it's super cool because they imagine themselves in the black robe, right? I forget which British prime minister said every backbencher MP keeps a prime minister's baton in his back pocket. I think ambitious law students and people who become ambitious law students earlier in life envision themselves in that role. And once that's lodged in your brain, you root for the power of that position. I think it takes a long time to unwind. And I want to also say that although I think that power should be, and again, it's not about changing the power of the court. The court needs to play the check and balancing role. In fact, someone said to me, wow, your panel is really timely. And I think, no, on the contrary, this branch is not my worry right now, right? My worry about this branch right now is that it should be strong and able to play a check and balance role. But I do think it would be good for individual justices to be less powerful. And here I'll just say a little bit more about how we could do that and why it would be a good thing, and then I'll turn it over to other people to speak. I think it's really bad for people to identify themselves and their own dispositions as the law, which is what you start to think if you're an Article III judge for too long, especially on an apex court. You start to think of yourself as a kind of titled nobility. That's not good. It's not conducive to listening to other people. It's not conducive to modesty in your decision making. And it raises the stakes of particular personnel decisions enormously, right? Presidential elections turn on who will get appointed to the court and so on and so forth. I think this is quite bad for multiple reasons, including that we have a system in which no political interest group can be confident that even if it's successful in electoral politics, cycle after cycle after cycle, it will ever get a majority coalition on the Supreme Court that is friendly to its interests, right? You can get lock-in perpetually. I think it would be a really good idea, the suggestion's not mine originally, to have a system where the Supreme Court, however many justices it had, 9 or more, where each president got 2 appointments, a new appointment each 2 years, and you push the most senior people off of the merits panel and onto a different panel of the court that does cert or shadow docket or something else like that. The virtue of this is, first of all, when you're going to cycle out at some point, you might identify yourself personally with the law less. There would be less of an incentive to appoint justices younger and younger. It would channel the impulse to legal change more into democratic politics and less into judicial selection. I think all of those things would be good. And so, though I do not, though I don't think any of this is going to happen on a foreseeable timeline, but I think that those would be salutary reforms. And I'll stop there for now.
I would just say, the 18-year term limit, as it's typically proposed, I mean, that would seem to be the lowest hanging fruit here, potentially. I mean, it's not an attempt to manipulate the judiciary or to drive it toward certain outcomes. And I think the reasons you just stated are ones that a lot of people recognize as having merit. So, they better get going on it, because it would only take effect for new people who go on there. And if we're going to see this in our lifetime, they better get started. But, okay, well, I'll let whoever, Tara, what do you think? Do you have a reaction to this? Sorry, I should use the titles. I apologize.
Oh, that's fine. I have lots of reactions, but I don't want to go on too long. So just a quick note on term limits. I think if you were starting a country from scratch, so it was 1789, and we're trying to figure out how to build a constitution. One thing that would probably not do, or in 2025, if we're starting a new constitution, one thing you would probably not do is give life tenure to federal court judges. I think that is probably true. That's not a world in which that I would pick if I were writing the Constitution anew. I think the issue with term limits is just once you have that system in place and have that system in place for well over 200 years, it's extraordinarily complicated to change it. It's extraordinarily complicated to change it in part for legal reasons, because these justices do come in with tenure during good behavior, which we have understood to mean life tenure for a very long time in our system. So what do you do with these justices? You could do it by constitutional amendment, which is very hard to do in our system. Some people think you could do it by federal statute. I don't agree with that, but the proposals are out there. So it's a really hard thing to do, whether you do it by constitutional amendment or federal statute. And I think for those of us who think life tenure means that, it would need to be a constitutional amendment, which would be very politically difficult, but frankly, so would a statute. So even if it would be a good idea from the beginning, I think it's really hard to do. And I think it's particularly hard to do in a system like ours, where the whole federal judiciary has life tenure. So do you have term limits just for the U.S. Supreme Court? Do you have it for the whole federal judiciary? If not, why not? So that creates lots and lots of concerns.
Maybe it's not such a good idea. I mean,
Yeah. And I have a lot more to say, but I want to make sure our other panelists have some comments.
I was waiting for you to chime in there, Judge, when she said that.
I've been holding my tongue for a while.
She was making sure you were awake. There's so much here that it's hard to know how much to say. I think one of the early proponents of the term limit, 18-year staggered terms, was Stephen Calabrese, actually, another Calabrese, known well to the Federalist Society. There's a lot to that I like. It doesn't fully respond to some of the concerns that Jamal raised, Professor Greene, that is, because you still are talking about a 9-member court. And I do think there's something different about the Supreme Court today in terms of the individualization of the justices, at least over the course of the decades that I've watched the court. And it plays out in a lot of different ways. The criticism of individual justices is more biting and more targeted. We've seen that this week. We made reference to it yesterday when we were talking about Justice Barrett. I think the security threats to the individual justices seem much more threatening and dangerous and scary than I remember in times past, although maybe I'm glossing over past incidents. But we are also seeing, on the other hand, we're seeing a lot of separate opinions, And the other scholars here can correct me if they think this is wrong, but it seems like we're seeing more. And that there is this almost cult of individualization on the court that I don't think is good for the institution, and I think is one of several reasons why it is worth seriously considering alternative proposals when we think about the structure of the course. Professor Grove, of course, is right that it's hard to, what is the expression, put the horse back in the barn after it's taken off, that we've had this system and it would be very difficult to change, certainly talk about term limits. It would be quite difficult to come up with a structure that would make sense. But it's not that hard to increase the size of the court. We've at one point had 10 justices. We started with 6. That number is not fixed in the Constitution, so there really isn't a serious debate there that you have to amend the Constitution to do it. And I do think that there is something really attractive for the reasons that Professor Greene highlighted, as well as what I see as this heightened individualization of the justices, to seriously consider increasing the size of the court. What I like about term limits is also something that has been mentioned, but I will say it even more emphatically. We are electing Supreme Court appointments when we elect a president. And I think it would be good to make that much more direct for the voters. So that is something that I like about the term limit idea. Each administration gets 2 justices if we stick with 9, for example. But that's for me a separate reason to consider that as a model. You know, some of the other things I will respond to, and then I'd love to let others chime back in. On the number of cases, it is very interesting also to see dramatic changes there over the course of the last few decades. The court on the merits has been deciding cases on the order of the very low numbers that it decided during the Reconstruction period. And this is after a period where at one point they were deciding drastically more. Even I think when I was in law school, they were still deciding almost 150 a term, or soon had been doing that soon thereafter. I should be careful about dating myself too much. But it is worth highlighting that when the justices proposed, and they were big proponents of full certiorari jurisdiction, one of the justices testified at the relevant hearing and said that he expected the court would hear roughly 500 cases a term. And that's not what they're doing, to put it mildly. They are, I think they would tell you, a lot of what they're doing now is, as Professor Greene highlighted, talking about they're dealing with the emergency docket. And that is taking up a huge part of their time and will continue to do so, I think, during the next 4 years. We've already seen it quite active, even just in a couple of months of the new administration. So that is also something I think that we do need to seriously be considering, how the court operates today, and can it be sufficiently responsive and provide the kind of due process that we tend to want from our court, and slow, methodical consideration of very important issues. I will say that another issue I hope we will talk about, I want to make 2 final points and then I'll be quiet. Well, first is if we talk about panels, a lot of countries do that, and I think it's really interesting to do comparative jurisprudence here when we talk about the Supreme Court and to look at how other countries do this. I have done a deep dive into the UK Supreme Court, which often sits in panels, and I had the privilege when I was on sabbatical living in England to interview all the then sitting UK Supreme Court justices. And one of the questions that I was most interested in was when you have high-profile cases and you're going to have to name a panel, a subset of the justices to hear it, how does that happen? And what I learned is that there was some strategic naming and control of how that panel is set. And so when we do talk about expanding the court and we think about panels, we do have to think about taking measures to ensure that panels aren't stacked to try and lead to a specific outcome. And that's a very, very hard problem, actually, one that we would have to confront and really think through. Then the final thing I'll say, and then I'll be quiet, is I can't get up here and talk about court reform and the Supreme Court's jurisdiction without, and I was prodded to do this in an earlier call by Professor Grove, talking about a tool that has been utterly forgotten and is still very much on the books and available, and I hope, Judge, you're listening, and that is certification. Because a lot of circuit judges and district judges will tell you we need more guidance on particular issues, and the Supreme Court's hearing all these cases, but what we really need is for them to hear these cases and give us guidance because we're all over the place. There's a very easy way to do that, and that is to certify a case to them.
It's the dissenters who want to certify.
Yes,
You know,
well,
I can tell you firsthand.
but it is, certification was also part of the certiorari transition and a big part of what was supposed to be the deal, which was you would still hear a lot of cases, even as we got rid of mandatory jurisdiction, and lower court judges would tell you, Supreme Court, what issues are really important to them and are plaguing their courts and on which they want more guidance. And yet the certification tool has really died down. The last attempt at a certification effectively failed. If you look back, interestingly, when you teach constitutional law, a lot of big cases were certified, it turns out, where you either have appellate courts saying, we can't decide, we're all over the place, or we don't want to decide. We'd rather just pass the hot potato. But in all events, it is a tool that is slumbering and out there, and it is available to lower court judges.
So let me just say a couple things briefly in relationship to this. I think the issue of changing the size of the Supreme Court, of course, has been very much in the air lately. It's long been in bad odor as a consequence of the debates surrounding the New Deal. And one notable thing about this particular suggestion, the rationale behind it, is that it tries to take a different tack than the normal rationale for trying to expand the size of the Supreme Court. That often the justification for expanding the size of the Supreme Court and the concern with expanding the size of the Supreme Court is primarily a partisan one. We don't like what the court's doing now. We don't like the outcomes of cases the court is currently confronting. Let's change the composition of the court so we can get a different set of outcomes. And that's a particularly disturbing use of Congress's authority to alter the size of the Supreme Court. And this proposal instead points us toward other kinds of reasons that we might have if we were thinking from scratch about the size of the Supreme Court, how big should it be? One way of thinking about this is if you imagine, we sort of said, if you're thinking from a constitutional design perspective and you're trying to decide how would you write this today, we probably wouldn't write it with lifetime tenure for judges, for example, if we were writing it today. Likewise, it'd be an interesting question whether if you were writing Article 3 of the Constitution today, would you leave it up to Congress to determine how many justices there ought to be on the Supreme Court? Would you just simply write that in to the Constitution and entrench it in the text in order to take this particular weapon away from Congress so Congress can't saber rattle about threats to pack the court? And there's lots of good reasons, I think, why you would actually want to just write that into the court, into the text of the Constitution. But one reason why they didn't, and one reason why one might be reluctant to, is you might think that over the course of a nation's history, as the nature of the court and its jurisdiction and its caseload changes over time, maybe you need more judges. And so, for example, I'd be much more open to the idea of maybe you need more judges if we also wanted to talk about the caseload of the court. If you wanted to talk about getting rid of the cert system, for example, or dramatically expanding how many mandatory appellate cases the court had to take so that their workload was actually dramatically heavier than it is now, then it might be quite reasonable to say, and you need more justices in order to handle that dramatically increased workload, as opposed to the pittance that they currently do, which really doesn't require very many judges at all in order to do that much work. But the Congress in the early 20th century made the decision that instead of expanding the court in order to deal with more cases, we'll shrink the number of cases by giving the court control over its own docket and allowing them to handle a much smaller workload. And as a consequence, they get by with a smaller number of justices on the bench as a consequence. And so if you wanted to go those two things hand in hand, it might be, I think, a plausible rationale, at least, for trying to think about doing it. I think one of the concerns one could reasonably have, though, is the functional one about how do you make a panel system work, and really large courts tend to operate with some kind of panel system. I think from a formal textual matter, in the context of Article 3 of the U.S. Supreme Court, is the U.S. Supreme Court is designated as being the one Supreme Court of the United States, which may textually exclude the possibility of adopting a panel system of the type that we see other courts doing. And I think that would have to require some real thought as to whether or not that kind of approach to how the court organizes itself would be consistent with what our Constitution currently requires. I'll just note one thing about the comparative point about the size of our court, and then one last point. So the comparative point to note is the U.S. Supreme Court is quite small relative to lots of other national high courts. It's not small relative to state Supreme Courts. So in the American context, the U.S. Supreme Court is actually pretty normal, even a little large relative to what's been the norm within our own national history. And moreover, if you look specifically at constitutional courts in other countries, they tend not to be dramatically larger than the U.S. Supreme Court. And so most constitutional systems outside the United States distinguish between their high court for their ordinary judiciary and a constitutional court that examines constitutional cases specifically. Our Supreme Court basically has become a constitutional court because they don't like dealing with things like mere questions of tax law and bankruptcy law and whatnot. That's for the peons at the circuit courts to deal with. The Supreme Court doesn't do that kind of stuff. So basically, our Supreme Court is a constitutional court, and in that sense, it's actually not, internationally speaking, that much smaller than most other constitutional courts. The final thing I would just note is a specific point that Professor Greene emphasized in his concerns here, and I think a lot of his concerns and discussion are really driven by the corruption that Anthony Kennedy made to all things associated with the court, which is that Kennedy, for a very long time, was the median justice on the court, and as a consequence had a lot of power. But no one selected him to be the median justice on the court. He just happened to be the median justice of the court, and it was a completely contingent fact that he was the median justice and that he was the median justice for quite some time. And so in most of American history, you didn't have a justice occupying that kind of role. There's always going to be a median justice. No matter how big your court is, there's a median justice, and if the court is evenly divided or closely divided, that median justice is going to have a lot of power, and is going to have a lot of power for a long time. And so it's impossible, if you're looking at collective decision-making institutions, to say, I just don't like the median. He has a lot of power. Who elected him to be king? Well, the answer is he became king because he's the median. And as long as he's the median, that's going to be true for quite some time. But there's no intrinsic reason to think that's going to be very stable or last a long time in general. It just happened to be true in the historical circumstances that surrounded Anthony Kennedy in particular. It's not true of our current court, for example. So it's not a 5-4 court for the most part. We don't have a long tenured median justice with the same kind of power at the moment. And it's quite likely that's not going to be true in the future either. And so I'm not sure we ought to worry or seriously reform our constitutional institutions because we look at the particular example of Anthony Kennedy and say, that was a terrible mistake. We shouldn't do that again.
All right, I have a few things to say. First, about Justice Kennedy. We might disagree with some of his rulings, but for me, he is a wonderful role model of conscientiousness, of dedication to duty. He mastered firsthand all the cases that I worked on with him, and he's a man of humility, kindness, gentleman of the old school, and I'm proud to have worked for him. I would like to offer a judicial perspective on a few of these things. So life tenure, one thing to bear in mind is that these structures that we're talking about are really a product of evolution over centuries. I mean, the judicial power itself is something that evolves really with from the beginning of when Henry II creates a professional judiciary in the 12th century forward. It's constantly evolving into what it had become by the time of the 1787. Life tenure in particular was something that was the product of a struggle over centuries. Of course, it was before you had life tenure, judges, and I'm talking about Anglo-American history, which is all I'm competent to talk about. The king obviously could remove judges at the king's will. And you look at the example of Edward Coke, who I would say, and I don't think there'd be a lot of disagreement, was the greatest jurist in English legal history, and maybe Anglo-American. One writer said that Coke to the common law was what Shakespeare was to literature, and so Coke is extremely courageous in standing up to the early Stuart kings as they're trying to move toward absolute power, as there was for the monarchs on the continent. And finally, in 1616, he crosses James one time too many. There was a case called the Case of Commandants. And this is just an illustration of the importance of having the judiciary insulated somehow from the political branches. It was this case called the Case of Commandants. And the short version is that James thought that the scope of his prerogative power, meaning his power that was discretionary, not bounded by law, that was at issue in that case. And it was. And he ordered the court to the King's Bench to stand down. He said, how dare you determine what the limits of my absolute power is? And Cook refused to stand down and defied him on that, and James removed him from office, fired him in 1616, because Cook was insisting on drawing lines around what was, executive power at that time. And it was only in 1701, in what's called the Settlement Act, that Parliament finally passed a law that gave judges, they could retain their office during good behavior, which is the phrase that we have to this day in the federal Constitution. So this is life tenure is something that was the product of a centuries-long struggle, and it's a struggle that is just unending, to subordinate power to law, that to have law over power, not power over law. And power is always, always seeking, one way after another, to get the upper hand over law. The other, I just want to give kind of a judicial perspective on judging a little bit, and just respectfully push back on the idea that judges are lawyers deciding political questions. I was a lawyer and now I'm a judge, and I think that there is a marked difference in perspective between a judge and a lawyer, or a judge and, say, a senator, somebody who's elected. As a lawyer, you have a particular object that you have a concrete end that you're pursuing, which is an outcome. You're seeking a particular outcome in a case. That's exactly what a judge must not do. A judge is only, I would call it, this is what Hayek called it, and I think he's had a good term. A judge's only concrete end must be upholding the legal order itself, not I want to advance this policy goal, I want to have more of a market economy in our country and fewer class actions, not I think we should have cleaner water or a better environment, or why are we worrying so much about those things? A judge cannot bring that to the adjudication of the rights of the individuals in front of him in a case. Our only end can be to uphold the legal order. So, this is a positive law system. Usually there's some document that is the ultimate source of the legal rule that we're always applying rules. It's not, court of chancery, like, what do I think? What's a good idea? That's not the question. The question is, what is the rule? And we have to discern what the rule is and then apply it honestly to particular facts. And so, it's positive law. So we have a body of rules now about how we construe that document. And there's good faith disagreement. Not all judges see it the same way, and by no means would I ever say, or am I saying, that there's only one way to do this and everything else is illegitimate. I mean, we would have disagreements up here, I'm sure. But there is a body of rules about how, it's case law at this point, about how we interpret text. You can know those rules in advance. That allows parties to predict with more certainty or more confidence where the boundary between legal and illegal conduct is. And then we take those rules and we try our best to discern how the person subject to that document, a statute, the Constitution, how the person subject to it at the time, how would they understand it? And we try to do that as honestly as we can. And so at no point is the question one of judicial will. It is instead trying to apply these rules of interpretation themselves impartially, and then discerning the substantive rule and applying it impartially in the particular case to the parties there. Is it perfect? No. No human institution is. Do some judges not even try? I think maybe to some extent. But over time, you can kind of tell, you know, do you make decisions that you don't like? If you always make decisions that you like, you're not doing what I'm describing. And if you make decisions that you just, it's beyond holding your nose. You really don't like it. You're distressed by it, but sometimes you must decide the case a certain way. Then, you know, then maybe you are doing it right. And, but the difference, I mean, John Adams, you know, a government of laws, not men. That what he's saying there, it's a government where we make decisions about coercion and individual rights in a case based on rules. That's what he means by laws. Rules, impartial application of rules, and not by will, meaning judicial will in that instance. That is ruled by men. And so I don't think judges or lawyers. There's a difference, and I honestly don't think I'm deciding political questions. I'm confident that's not what I'm doing. And let me just say this: we have, you know, just as an example, we have 4 new colleagues from President Biden. They are doing on my court. They are doing what I described. They are doing their level best to discern, not make up, but to discern the law impartially and then to apply it impartially in their cases. This is an ideal, yes, but it is one we can realize. And I just want it, from my perspective in front of a group of students, I want to tell you that this is something we can achieve in a meaningful sense, in my humble opinion. Okay, you all go.
If I may, I wanted to just offer a couple of observations based on what others have said and maybe a couple of clarifications. So one is Professor Whittington mentioned that the Supreme Court is in effect a constitutional court, that it resolves constitutional questions. Constitutional courts exist in many countries around the world, and they are generally smaller than apex courts. I think that's right. Though what's distinctive, I think, about one of the things that's distinctive about the Supreme Court is that it's both a constitutional court and an apex court. Most of its docket is not constitutional cases. And among, again, I'll go back to the 30 largest countries in the world, there is no court of one of those countries that hears both constitutional and non-constitutional cases that has fewer than 11 justices, and many of them have many, many more than that. The second point is about the constitutionality of a panel system, whether it conflicts with Article 3 injunction that there be one Supreme Court. I don't think it does. I don't think we think of the Sixth Circuit as multiple Sixth Circuits because it sits in panels. I think so long as there's, I think especially if there's an option for en banc review of whatever the panel does, it's a single court. If they're rotating among panels, I don't think there's any real question about that. Third, just to go back to this question about life tenure and its importance over time, it has been important over time. It was a significant innovation at the time, as Judge Kethledge mentions. But as he also mentions, the alternative to life tenure was, you know, service at the pleasure of the king. And the pathologies associated with that simply don't apply to a system with a tenure process of some kind that says you serve for a definite term or serve until a certain age. So this is what almost every country in the world does. This is what every state does, other than the state of Rhode Island. So, you know, there's nothing sort of unusual about it. Again, I think it's fairly clear if we were starting from scratch, this is what we do. But I am sensitive to what Professor Grove mentions. Of course, we have a long history of life tenure, and that is a significant factor in deciding how and whether to change things. I think we have to be very mindful not to endorse a kind of permanent status quo just because we've done things a certain way for a long time. How do you do it? How do you make it constitutional? I think it's important to clarify that the 18-year proposal and a lot of the proposals that rely on a statutory amendment would not sort of kick the person to the curb at the end of the term. They would remain a Supreme Court justice. They would have different statutory duties. It is already the case that there are, including Justice Kennedy, there are Supreme Court justices right now who do not hear merits cases. They are Supreme Court justices. If they were not Supreme Court justices, they could not sit and hear lower court cases, which is what David Souter has done in recent years. So it's already the case that it's not an irreducible minimum of a Supreme Court justice if they hear merits cases. That's been the case for about 100 years when we've had a senior system for SCOTUS justices. Why just the Supreme Court rather than other federal courts? I think quite simply because the individual justices on the Supreme Court exert an enormous amount of power, both because they are apex, both because they do sit and bank in every instance at the moment. I think there are other, and I'm talking about term limits for the moment. There are other reasons why there are other innovations that you could do to reduce that power, but the Supreme Court is, I think, unique in this respect. And then the last point, a broader point in response to Judge Kethledge about political questions. So, and I just want to make clear what I mean when I say that small numbers of elite lawyers decide political questions over their lifetimes when they sit as Supreme Court justices. By political questions, I don't mean they decide partisan questions. I don't mean political as something pejorative. I don't mean political as something as an exercise of will. I mean political as they exercise power over our collective governance. That's what I mean by political. I don't mean it to be an insult. And it requires the exercise of judgment. It does not simply follow from a set of rules. When we're talking about constitutional interpretation, often when we're talking about statutory interpretation, I agree with Justice Marshall and McCulloch that the Constitution is not a legal code. There are some rules in the Constitution, there are some standards in the Constitution, there are some principles in the Constitution, all of which are part of the Constitution and require application in individual cases. And that, again, requires the exercise of judgment. Someone can be operating entirely in good faith. And it still is the case that we would not want that one person to have the enormous amounts of power that Supreme Court justices have over their lifetime. And again, I'll go back to a really important point here, which is, and this gets into something Professor Primus mentions about regularization of retirements, is part of the problem is timing your retirement so that someone who shares your political ideology replaces you and serves under similar conditions. This is utterly pathological, and I think anyone who thinks that that's a good system, I'd like to have a long conversation with them.
Floor is open here. And we can talk about jurisdiction. We should at some point.
We should talk about jurisdiction.
That's a really interesting question about, when does that undermine the separation of powers and so on. But anyway, floor is open.
I just wanted to talk about court packing / expansion, but I do have to say a couple words now about term limits as well. So some of the proposals say 18-year terms, president gets to appoint a new justice every couple of years, which of course means court expansion, right? Like you're going to get more justices, especially if we do it by federal statute. So then what happens on the Supreme Court? So many of the proposals say, well, the 9 newest folks can serve on like the main court, hear all of the appeals, all the cert cases, and the other justices can do other stuff. Well, what would that other stuff be? There are different proposals. Some say they get to do original jurisdiction cases. I don't know if you guys know what those are, but there are a lot of water disputes between Florida and Georgia. My personal favorite is the suggestion that the most senior justices just serve on the Federal Rules Committee, and so design our federal rules of civil procedure, federal rules of appellate procedure. Why do I mention this? When a president nominates a person to the U.S. Supreme Court and the Senate confirms them, they are confirmed to an office. And so it's not just that we're messing with traditional notions of good behavior. Now, the Constitution does not say life tenure. Let's be clear about that, but it does say good behavior. It's also what is the office? And I think there are a not insignificant number of people who would think the office has changed substantially if someone no longer performs that appellate court job, but yet is doing just original jurisdiction or even the shadow docket or the Federal Rules Making Committee. And this doesn't necessarily mean it's unconstitutional, but there are at least really serious constitutional questions about term limits. And I think it's also important to recognize that now when justices step down and retire and serve on lower federal courts, they're doing it voluntarily. And I think there's a big, big change for judicial independence if justices are forced rather than doing something voluntarily. But I actually wanted to say a few words about the court expansion thing, but I want to pause if other people want to chime in on any of this stuff. Did you want to say something? I will stop.
Sure. I guess my view is if it's done properly, limiting terms by creating more seats and moving the most senior justices into other roles within the court is not a problem for judicial independence at all. It's a problem for the power and maybe the ego of the individual person who's been moved. I'm sorry, like you've been a Supreme Court justice for 18 years. That's quite enough for one lifetime. And not just that, if you had another panel that was in charge of certiorari and or shadow docket and or something else, that's actually still quite a lot of work and quite a lot of power. You know, I mean, I think most of you in this room would accept that job if it were offered to you.
I wouldn't.
Well, we'll see. We'll see. Right? I do want to say a couple of other things, right, on this on this subject. One, Professor Whittington is of course right that the Supreme Court in its size is not an outlier with respect to state Supreme Courts. But it is, and I don't want the point to go by, Professor Greene mentioned it, an outlier with respect to life tenure, right? Only Rhode Island does life tenure, right? And those two things are related to each other, right? The small size exacerbates the life tenure problem, or at least, like, from some perspectives, right, it does. And I should also say that I agree with Professor Whittington that the experience of Justice Kennedy, or Justice Kennedy on the heels of Justice O'Connor, magnifies in many people's minds the idea of the overly powerful justice beyond what we normally have. But I don't think of that as the core of the problem. I mean, I don't think that's a good thing, but I don't think of it as the core of the problem. In the years when Justice O'Connor and Justice Kennedy were the swing justices, Justice Scalia and Justice Ginsburg sat on the court, and they both had cults of personality. I consider myself lucky and proud to have worked for Justice Ginsburg. But I don't like cults of personality, even when it's a person I like. I think they're bad in Republican government. And I think that life tenure encourages cults of personality because they're not like us anymore. They're celebrities, right? They're not bureaucrats. And I think it changes how they see themselves. I think it changes how people see them in relatively unhealthy ways. I think that, and then two other quick things, right, for here. One, the very important things that Judge Kethledge says about, you know, what he thinks he's doing and what he's committed to doing as a judge are super important. They're essential for a rule of law system, right? The way that Judge Kethledge described his consciousness and his project judging cases is absolutely the way we would want judges to approach and decide their cases. And I don't think it's a fairy tale. I think that most of the time, most judges, in my experience, are proceeding like that way or close to that way, you know, to something like the best of their abilities. And thank God. I also think that human beings are fallible and lack perfect self-knowledge, and that there's a really important difference between the kind of court on which Judge Kethledge sits and the Supreme Court of the United States in the following respect. The U.S. Court of Appeals, including the Sixth Circuit, decides lots and lots and lots and lots and lots and lots of cases, many of them technical, many of them on cases where there's well-developed precedent, right? And so the cases of first impression, the cases that are really open where the positive law materials won't get you there are relatively few. When I was in law school, from reading the cases that I read, I could easily get the idea that anything was possible in any case. But that's because the cases that you read in law school are the hard ones, right? I then clerked on the U.S. Court of Appeals, right, the court that Judge Kethledge now sits on, and was astonished and delighted to discover this is not so, right? That in like 95+% of cases, there is a right answer. And a panel of 3 intelligent, competent, hardworking judges, regardless of who appointed them, will come to that right answer, right? They work together and listen to each other and so on and so forth. That's great, right? The thing is, there's a couple of percent that aren't like that. There are a couple of percent that are really open questions where the positive law doesn't ultimately decide, or at least where you cannot predict, you would go wrong by predicting that judges of good faith and technical skill would all converge on the same answer, right? There's a small set of cases that are like that. And those are the cases in which different people's judgments and intuitions and worldviews and values are going to come into play. The U.S. Court of Appeals, and the U.S. Court of Appeals, that's an exceptional case, right? That's not what they're doing every day. The U.S. Supreme Court selects for that case, right? It's a much higher proportion of what they do, right? Which makes the mechanical, like rule-based view applicable, less applicable, right, applicable to a smaller percentage of their docket, or to a smaller percentage of the decision weight of a given case on their docket than at the Court of Appeals. This is actually why when I had the privilege of clerking at the Supreme Court, my favorite cases to work on were the technical ones, right? The technical, non-ideological, like we're gonna work it out cases. The last thing I wanna say is about independence, which is oh so important. And here, like, exactly as Judge Kethledge says, life tenure emerged in English-speaking law as an alternative to the dependence of the judges on some political authority, right, at the time of the Crown. And that independence, I think, is indispensable. But it doesn't require life tenure, right? It requires some relatively long tenure. It requires that you can't be dismissed for doing something that some other authority doesn't like. But it doesn't require it doesn't require life tenure. If you are going off or getting a smaller pile of duties at some date certain in the future, you can still act independently. Here's what I think it does require that we ought to worry about. You never, ever, ever want a judge to say to himself or herself, I'm not going to be a judge forever. How am I going to make a living after I'm done? Because that biases the judgment even of people who are trying to act in good faith. So it's my view, and this is actually my view for all federal judges, not just for Supreme Court justices, that part of the deal of taking the seat should be that you are permanently prohibited from making money in other ways, right? After you leave the bench, you get a lifetime pension. Like you can, when you leave the bench, assuming you've done a certain number of years of service, you'll continue to collect your salary, even though you're not deciding cases anymore, right? So you'll be fine, right, economically. But that's it. You cannot go out and lawyer or consult or go on speaking tour, or anything else like that that might dispose you to curry favor with someone because you're going to need the money in the future. People sometimes say to me, if you impose that limitation, you would denude the quality of the people who are willing to be judges because you make their futures less lucrative. And I'm not worried about this at all. I think there are enough people lining up to be judges. Maybe they would do it later in their careers. I don't know the person who's going to turn down a Supreme Court justiceship because they're going to have to retire at that salary.
Do you guys want to? So I just wanted to talk about the court expansion idea. So I think it's important to, when you're thinking about how big can it be, 15 to 25 is actually both very large in terms if they sit on banc. And at the same time, it's also still a tiny, tiny fraction of the American population. So I'm not sure that there would be a huge gain in that respect at the same time that we're causing some efficiency problems, unless there is a panel system that went into effect. Professor Tyler's already mentioned some potential problems with a panel system. I just want to say that the constitutionality of it is not at all clear, and kind of build on what Professor Whittington was saying. So a lot of people say in response to the argument, well, you can't have a panel system for one Supreme Court. They say, well, we have panel systems at the lower federal court, so what's the problem? Well, the Constitution doesn't say there has to be one Sixth Circuit or one Fifth Circuit. The Constitution says such inferior courts as the Congress shall from time to time ordain and establish, right? The inferior courts can look like whatever Congress wants them to, and they don't have to look like any particular thing. And that doesn't necessarily mean panels are invalid at the U.S. Supreme Court. It just means the fact that we have panels at the lower federal courts doesn't really tell us very much. But I think history actually tells us a fair amount. So Congress has considered splitting the Supreme Court into panels, just as Congress has considered various options for dealing with a growing workload on the Supreme Court. It considered it in the 1860s. It considered it again in 1890. It was 1891 when Congress created certiorari jurisdiction and the certification process, and I agree with Professor Tyler, please use it. They created that in 1891, but they considered other options, including a panel system. So there was a minority report of the Senate Judiciary Committee that said, hey, let's split, let's have a bigger court and have them hear cases in panels. They'll be able to hear a whole bunch of stuff. We've solved the workload problems. No problem at all. And the response of the Senate was, well, is that constitutional? And a number of members of the Senate said, no. Other people said, well, but if they decide the cases in panels, will those decisions be as legitimate as decisions by the court as a whole? And so ultimately, the Senate overwhelmingly rejected that in 1890. And over the years, as it has come up, some members of the Supreme Court have said, yeah, well, people come up with this idea, but we think it's a real problem with the one Supreme Court notion. Now, what does this tell us? It doesn't necessarily tell us how a judge should decide a case. That depends on how much history and tradition should work into judicial decisions. But it tells us that there's been a political decision for a really long time that panels do not comport with our federal Constitution, which makes the size of the Supreme Court much more complicated, if true. The final thing I'll say is I very much appreciate that Professor Greene is doing this in a nonpartisan way. And I, knowing Professor Greene, that is absolutely sincere, and he really does believe this. But throughout our history, court reform has been partisan, sometimes from the left, sometimes from the right. It has been a partisan project. And when it has been nonpartisan, it has often failed. So a lot of people probably don't know that in the 1950s, this was in part a belated response to President Roosevelt's court packing plan. There was a constitutional amendment proposed that would have both fixed the size of the Supreme Court at 9 members and would have prevented Congress from ever stripping the Supreme Court's appellate jurisdiction over constitutional cases. This thing got through the Senate, actually got a 2/3 vote in the Senate, went to the House, and members of the House said, well, we don't know. But we're worried about exactly the problem that Professor Whittington mentioned earlier, which is that if you fix the size in the Constitution, maybe that will make it harder for future changes, for better or for worse. But ultimately, there just wasn't political support. And I will say, 6 days after that constitutional amendment failed, Brown versus the Board of Education came down, and then there was no room for compromise at all when it came to court reform. But boy, were there a lot of proposals for court reform.
Well, we've got about 10 minutes before we go to Q&A, so no, we're not doing it yet until Q&A. We'll try to get there soon. We got some pent-up demand, apparently. But let's have a few, let's talk in the time we have about jurisdiction stripping. Sorry, Professor Tyler. Okay.
Judge Tyler.
You've written about this, and I thought maybe you could start us off and some thoughts about, you read the Constitution, it just seems like sort of this absolute power on Congress's part to strip the Supreme Court or the federal courts generally of jurisdiction. I mean, obviously, you could take that to a point where we don't really have a constitution anymore. So what are your thoughts?
How long have we got?
You got,
No, I'm kidding.
The timer's right there.
I'm
so.
kidding. So everyone up here has written and thought a lot about jurisdiction stripping, and it's interesting because I was teaching a very high-profile constitutional law case last week to my students, and it was a case involving really salient questions of first impression, and it made me think about jurisdiction stripping, even though it wasn't a federal courts class. And here's why. So many of the questions when we talk about jurisdiction stripping, including the very one that you pose, the sort of hardest one, can Congress strip jurisdiction over constitutional questions, we really haven't resolved. And in Hart and Wexler, and this predates me, I did not write this, the editors ask, is it maybe healthy that we haven't resolved this question? And what made me think of that is that we've had some high-profile, very salient cases where the court has had to answer really momentous questions of first impression that, frankly, I wish they hadn't had to answer. And it made me think of jurisdiction stripping, that there really is something healthy, that some of these boundaries are a little gray, because it means that we don't have a direct clash between the branches over these really important sort of fundamental questions.
I mean, people want law to be a backstop, and they want courts to decide
Right.
these things. Or anyway, go ahead.
Well, no, that's right. And then also law students, they hate this because they want the rule. They want to know what's the answer for the exam. And don't take my class because it's all muddy. It's all unsettled in my class. Let's debate it. That's the fun. But you're right. We need law as a backstop, and we need the courts to have. And indeed, that was the larger vision of the separation of powers: is that the courts would play this role. You know, Hamilton and Madison both spoke of the courts as the guardians of constitutional rights, their words, and Hamilton talks about how the courts would stand between, in particular, what was thought of as the most threatening branch at the time of the founding Congress and the people. And, well, I mean, we're talking about reviving Congress here, so I don't know how threatening it is now. But in all events, the larger point is that clearly there was an idea that the courts were going to play a very significant role in the balance of the constitutional structure. John Marshall talks in Osborne and elsewhere about how he thought that the branch should be on par with the other branches. And if you allow Congress to go to the extremes of jurisdiction stripping, then obviously they can undercut that role quite drastically, if not really almost entirely, when we're talking about constitutional questions.
So where would you draw the line?
I think it's darn important for the courts to have some jurisdiction over interpreting the Constitution. That's pretty broad, but I think that's really important for the grand experiment to work.
I mean, it's kind of another application of Justice Jackson's point about the Constitution is not a suicide pact, and including not for itself, perhaps, right?
I think that's absolutely spot on.
I mean, I'm just floating ideas here, but yeah. All right, who else has thoughts on this? Folks have written about it.
I think we have an important history here too. Jurisdiction stripping has been tried many times and has failed in the political process. That doesn't mean it's unconstitutional, but it means that Congress has throughout history recognized, or at least effectively given the courts a lot of room to maneuver. I will say, I think whenever we're talking about court reform, we should think seriously about how the conversations affect the norms of our society. And this is actually something I worry about a lot right now. Whenever anybody proposes any kind of attack on the federal judiciary, and this is something I've worried about for a long time, whenever you're thinking about court reform, whatever your personal motives, I think it's really important to ask yourself how you would feel if, just say, your worst nightmare of a president, or from either side, were the one making the court reform, and how would you feel about it then? And I think that's something to recognize for jurisdiction stripping, for term limits, for court packing, and everything else. And I think when we think about how we would feel if the other side, someone we don't politically support, were proposing it, we have a very different reaction all of these court reform proposals?
Just two observations about jurisdiction stripping that I think it's important to keep in mind. One is that jurisdiction stripping is a very broad category. Congress has altered the jurisdiction of the federal courts many times before. I don't think anyone doubts that they have some authority to do that. And any particular quote unquote jurisdiction stripping proposal doesn't become constitutional or unconstitutional based on whether we call it jurisdiction stripping or call it something else. We have to ask another set of more specific questions about what they're doing, why they're doing, what the effect of what they're doing is, which leads me to the second point, which is I think it may well be productive to think about jurisdiction stripping in much the same way we're encouraged to think about the relationship between other branches, Congress and the president, by Justice Jackson in steel seizure cases, which is to say, is this something where Congress is actually interfering with core powers of the judiciary, as opposed to, well, we thought it was unproductive for them to hear this set of cases or that set of cases. We're building a different kind of institutional structure to handle this particular kind of problem. That's ordinary governance. The courts are not mystical permanences that have to stay the same way all the time. But again, much as we think about or tend to have historically thought about executive power, there's a kind of dialectic that you have to think about between what the core powers of the courts are and what powers Congress may have to regulate those powers.
I just wanted to make a brief political science point on relative to jurisdiction stripping in that jurisdiction stripping, like the size of the court, there's clearly a lot of space there for Congress to act because the Constitution is pretty clear that there's some constitutional authority, although there may be some questions on the outer bounds of how that power gets used or might be used. And one implication of that has been across American history that this is a kind of thing that the Congress and those who are unhappy with the court in Congress use to reach for in order to rattle sabers at the court. And so if you're unhappy with what the court's doing, you threaten to do things to them that they don't want done, like stripping their jurisdiction or expanding the size of the court or various other kinds of reforms. But those are two of the big ones that frequently get proposed in Congress. And so there's been a tremendous amount of proposals over time to strip the jurisdiction of the court for one thing or another across congressional history. Most of those don't go anywhere, but most of those have the primary goal of simply trying to intimidate the justices. And there's a fair amount of empirical evidence they frequently do intimidate the justices. And so we should not only sort of have legal questions about when exactly can you strip the jurisdiction and under what kind of circumstances, but just recognize sort of there's a bare aspect of power politics involved here, that as long as Congress has some authority to alter the jurisdiction of the court, they will threaten the court with that in order to try to get the court to do what it wants.
Okay, very good. Well, why don't we open it up for Q&A? We're about at that point. And these two gentlemen in the middle, okay, you guys get to go first. How about you can go, sir, and then you can go after that. Since they had their hands up 10 minutes ago, and then we'll go from there.
Well, thank you. Gregory Faslios, Texas A&M. So a practice has become commonplace in the lower courts, and we've even seen it at the Supreme Court, albeit without consequence, is the contingent retirements. And my question is this even a lawful practice? And if so, is it something that we should be concerned about? That's my question.
I'm going to let other people talk about that. I'm going to conscript Professor Greene. What do you think?
So, I find it mildly uncomfortable, but I'm not sure that it makes me more uncomfortable than lots of other practices that we have, and some of which we've talked about. One of the points I think it's worth making here is that if we're trying to think about when are we worried about political pressure and political considerations being attached to the decision whether to retire or the decision even to make certain kinds of decisions in cases, the fact that we have a senior system, the fact that we have a retirement system that gives significant benefits to judges when they retire, opens the door to various kinds of pressure being put on judges to retire or not to retire. That has been the case for a long time. If we think that that's okay, then I find it odd to think that it's not okay to say, okay, here's the date certain when everyone just retires, which would eliminate the kind of pressure that one is worried about when there are, and again, this has happened many times throughout history, especially at the Supreme Court, of various incentives being put in place for someone to retire. If there's a date certain, that goes away.
I mean, whether it's legal, it's hard to say. I guess what's hard is to see how that could be litigated, how somebody would have standing to challenge that. So, I mean, some things are governed by custom, in life generally, rather than by kind of a positive law or law. And this maybe was one, but now we've had departures, and so we'll see. I mean, I think the thing is that it doesn't take effect until it does, right? And then, I guess the idea is the person can change her mind. But I don't think there's a clear answer to this. So how about this other gentleman? And then we'll, and then we'll try to
Thank you.
have some other folks.
Sebastian Griffin, University of Idaho. My question, and I think Professor Grove stated it in my mind clearly, this has been a partisan issue, and when it gets brought up, it's from a partisan perspective. Do you all, because you've been around and experienced enough, notice a trend that judges being confirmed, whether it be Supreme Court or lower courts, are more politically polarizing? And if expanding the court or packing the court or term limits comes into play, do you see that as a solution to lessening the political polarization that we're seeing in certain rulings and opinions? Because I think from a individual's perspective, a taxpayer perspective, wherever you come from, the issue is more from we want to avoid political polarization and a political narrative and just get down to the root of what is the law.
So I think the question is partly about the confirmation process, right, and how difficult it has become. So I just want to say that my own observations in conversations with federal judges, and I suspect many of us agree with this, I think we believe federal judges are trying to do their jobs and rule on the law and not politics. And I think there's a general sense of that. But there's a perception that that's maybe not what they're doing. So the confirmation process started to get really ugly at the lower federal courts in the 1980s. And it continued to get really, really ugly as time went by. And I just want to say it was bipartisan ugly. Both Republicans and Democrats did pretty horrible things when the other side was nominated for the federal bench. This went under the radar screen, I think, for a lot of folks. When I dug into this history, it didn't surprise me at all that the filibuster was obliterated. I don't think term limit solves that problem, because I think you're still going to have fights over people serving for 18 years, as Professor Primus was saying. That's still a long time and a really cool job, and yet we're going to have the fights every 2 years if we do that at the Supreme Court level. In terms of how do we address that, I think we all have an obligation in terms of how we talk about our government institutions, not to lambast them all the time, whether we're talking about the federal judiciary or Congress, or the presidency. I think we actually have an obligation, or the federal bureaucracy for that matter, to talk about them and respect that the people who are working in these institutions are actually trying to do a good job, even if they disagree on what qualifies as a good job. So I think there are real issues when with political actors on both sides of the aisle are attacking federal judges as partisan without kind of looking at the whole picture and recognizing that, as Judge Kethledge was saying, actually well over 90%, well over 95% of lower federal court opinions are unanimous. And I think that's one of many facts we should talk about more.
But
I wrote this one down. Okay. a key theme to me today seems to be, by the way, I should start. My name's Eddie, 2L at Notre Dame Law School. And thank you guys all for coming and talking about this issue. A key theme to me seems to be concern about the accumulation or centralization of power in the Supreme Court, or a subset of it, or even a lone justice. And underlying that worry is that certain interested ideologies or factions can entrench themselves into power. That's how we started this whole thing, about retiring and making sure someone else that thinks like you can take your seat. And that seems to me to be a problem only if those factions or ideologies are abusing that power, if they are acting in a way that is beyond the scope of their authority. So I have two questions that kind of play off each other. One is, how do term limits or a larger court answer the problems of judges acting outside of their authority? And two is, what is the role, and that was a little bit just answered, but wasn't fully kind of fleshed out. And then two is, what is the role of other actors in facing this problem? So the other branches, kind of a more departmentalist approach, law schools in terms of teaching the law and properly criticizing the court where they act outside of their authority, and the bar in general. And do we need to improve in kind of holding the court accountable on the merits? Is that really the big issue?
Something that I've been thinking a lot about, and it somewhat answers your question. I'm not going to answer every different aspect. You kind of cheated there with two. I'm just kidding. But that I've been thinking about, one of the things that I spoke about in my opening remarks was the individualization. And I think it's something Professor Primus was talking about with this sort of cult of personality. Professor Sherry at Vanderbilt Law School has proposed that the Supreme Court stop signing opinions with individual justices' names. And it's a really intriguing proposition. And here's what I would ponder, or I would put for all of you to ponder, which is if you are opposed to the idea of unsigned opinions, that is to say individual justices don't get to slap their names on their concurrences or their majorities or their dissents, why are you opposed to it? Because I think fleshing out the response to that question can be really insightful about how you think about the Supreme Court, whether you think about it as a team of individuals or an institution. And it's not unclear to me that we couldn't have a similar rule on courts of appeals.
I mean, just on this point, my kind of quick reaction is the reason that comes to my mind is accountability. And I can just tell you that there's a difference between joining a per curiam opinion and having an opinion with your name on it. And you're just accountable, and you kind of bear a responsibility that I personally just feel we don't. When it's, in a sense, we're adjudicating rights in both situations, but I feel a greater responsibility and accountability when it's signed by me than when I join a per curiam. It's almost it can be a way to hide almost.
Do you think you would feel that on if you were on the Supreme Court?
I'm so happy I'm not on the Supreme Court, but
I believe he's dodging the question. No, I'm just kidding.
No,
I'm kidding.
I think it's another. I don't know. I honestly can't speak to that. You'd have to ask one of them, but I think that it's information that the country wants. We want to know. We want, like when I said you can tell if somebody's just ruling the way that person wants to in every case. It might be hard to tell in one case or in 3 cases, but if, every single time that person comes out, if there's a colorable window, in most cases there's a colorable window of decision, and if every single time that person comes out pegged at one end or the other, that tells us something. And we wouldn't have that information if they were per curiam. Okay, whatever. Okay, over there. Whatever.
Yes, thank you very much. So this question...
Why don't you just stand up if you don't mind?
Thank you very much. So this question is very much pertinent to what you just said there. I guess for me, the most curious part about Congress's potential to oversee and hold the Supreme Court in check is its ability to impeach and remove a justice from the Supreme Court for good reason. But from what I understand, Congress has never exercised this constitutional power. Can any of you speak to why that might be?
Professor Whittington?
So I have a book that you should go buy.
Did you plant him?
I did. No, it's a plant. I'll give you the $5 after. So there's been one justice of the Supreme Court that actually was impeached by the House and not convicted by the Senate, and as a consequence not removed, which was Justice Samuel Chase during the Jefferson presidency. There's been lots of threats to impeach justices subsequently, but those tend not to go very far. And there's sort of both a sort of base level politics explanation for why they don't go very far, and then it's worth thinking about what the constitutional rules and standards ought to be surrounding that as well. So let me just bracket the substantive constitutional issues about high crimes and misdemeanors and how they might apply to various judicial decisions. There's just a baseline political difficulty of actually removing a judge through the impeachment process, right? Relatively easy to imagine getting a bare majority of the House to impeach a judge, but in order to remove a judge, as we have encountered through recent impeachments more generally, right, a very high bar in the Senate because it requires a supermajority, which almost always means you got to be able to reach across the aisle and get some degree of bipartisanship in order to agree to remove somebody through the impeachment process. And if where you're talking about impeaching people and removing people for is the substance of their decisions, for example, you think they're behaving lawlessly on the bench, there's going to be partisan disagreement on that almost always. And as a consequence, extraordinarily difficult as a practical matter to actually make it happen.
I think that's right. And I think in a way that links together a number of the questions that have been raised, there would never, it's really difficult to imagine an impeachment of a Supreme Court justice that doesn't turn very substantially on the different values and worldviews of that justice and of supermajority in Congress, right? And one of the reasons that it would be super difficult to get a supermajority of the Senate to agree to remove any particular justice is that these people are so salient, right, to like the exercise of power in the system, right, friendly to or opposed to their worldviews, right? I think that it is a noble but impossible dream to imagine that we will have a Supreme Court against which there will not be partisan-based complaints. Right? As long as we have a Supreme Court that acts as a constitutional court and that decides questions that people care about where the positive law doesn't dictate unique right answers that any competent person must recognize, there are going to be people who accuse the justices of acting lawlessly, right? The people who don't like what they're doing. There is no previous moment in American history where people did not feel that way about the Supreme Court. People are going to feel... People aren't always going to be equally justified about whether the justices are behaving badly, but we will always have it as a sociological fact that there are people who criticize the courts in that way. And sometimes the criticism will be warranted, right? My own view is that because we can't cure that, right, what we could at least do is channel political disagreement about what the court should be doing into electoral politics, rather than into confirmation process, judicial selection, and so forth, and that we could do that by having a system going forward where you have some guarantee that if you win elections, you can appoint the people who you will be less angry at, right? It won't eliminate partisan-based complaint about the court, but it might distribute it through the population, which I think is much healthier in a society than to have one or another interest group for decades and decades, right, thinking that it's the one on the losing side. That's bad for legitimacy. And to Professor Grove's very important criterion, for a kind of reform like that, I wouldn't care what president implemented it or what Congress, because it would only work if it's forward-looking, right? You say starting 4 years from now or whatever it is, we're going to start doing it that way.
Okay, I'm sorry, but we're out of time. So let's thank this panel. Okay.